Mickles wanted the mayor to buy his land at a fancy price. Mayor refused it. So what Mr. Pickle did is, he sunk a deep well in his property, pumped all the matter as a waste into a nearby water channel, and because of this, the subterranean connection between both the land, the city water reservoir went dry. However, when Mayor of Bradford sued Mr. Pickle, even though there was a damage to the town of Bradford, the said damage was not in pursuit of a legal injury. Just as the mayor has a right to pump the water from his land, I also have a right to pump the water. If I own a 10,000 rupee and if I want to light my cigarette, I can light my 10,000 rupee in the candle and light my cigarette. Because I am the owner of it. So the way I can also use the water in my land. The very fact he did it with a bad motive does not make an otherwise lawful act unlawful. Please remember now, the water law has changed. But water law has changed because I don't know, Mr. Amar Anand, you may know it, the Deputy Chief Minister of Tamil Nadu, Mr. O. Pannirselvam, sunk the biggest well in his village, right? And it is a huge well. So during the dry season, all this water in his village will come to his well. The entire village went on an agitation and made sure that the well he made is made over for the benefit of the village. So if you look at this water law, Mayor of Pickles versus Bradford is no more the correct law. But if you look at the law of tort, it still remains the correct law, namely, malice has no role in law of tort for the purpose of determination of liability. Okay? Except in a tort like malicious prosecution. But malice will have a role in determining the compensation once the Tortious Act has been established. So there are two parts in a decision. The first part is establishment of tortious liability. For this, malice is irrelevant. The second aspect is determination of compensation after the tortious liability is established. For this, mental element is relevant. Alright, this is what I have said, and please remember, this point also I discussed it earlier. Under law of tort, fault is the basis of liability here. If I am not at fault, I don't have to pay you anything. But this aspect of law of tort is changing in a very big way. See, this is a very dubious thing. Somebody is dying in a hospital, a doctor dies due to corona. He probably gets 50 lakh. Soldier dies, he gets 1 crore. The Mahut in a temple dies, all of them are dying in government duties. He gets 2 lakh. You understand what I am saying? This is skewed. It is not equal. Everybody dies in pursuant of a government duty and everybody should get the equal compensation. So the New Zealand, for example, let us take this case. In Thoothukudi there was a firing, Sterlite factory. 20 people who were members of an unlawful assembly were shot dead. Each one got a compensation of 1 crore of rupee. In the neighboring village, there was a communal riot. Each of the victims gets only 20 lakhs. Both are members of the unlawful assembly. You understand? In Tamil Nadu, there are various reasons. I don't want to go into that. So what we are now heading towards is liability even without fault. Sometimes, under law of tort, we will simply order because we have now a welfare state, right? Because it is a welfare state, victims of accidents and victims who suffer unexpected damages must be compensated so that, Okay. Now, we will discuss general defenses. Uh, Defenses are very much part of your syllabi. Okay. General defenses is the third chapter, all right. Third of the unit actually. In tort law, I would expect at least about 2 or 3 questions from general defenses. Negligence will probably have 1 or 2. Nuisance 1. Absolute liability, strict liability 2. That is how I expect it to split, and this is I'm doing it for the first time, and therefore I'm not will. That's why I want it to be reviewed. Okay, general defenses are very very important. Okay, first is voluntary non-fit injuria. Consent to an injury will not give rise to a cause of action. For a defendant to successfully avail this defense, he must prove 2 things. Number 1, knowledge of the injury. Number 2, consent to the possible injury. Earlier, you could give consent to the injury later than you suffered the injury. Or the consent can be implied in the circumstances. It can be express consent or implied consent. But now the law is PIC. PIC means prior informed consent. The earlier law was implicit consent. Consent need not be expressed. In some cases, even today, you can infer implicit consent. I'll come to that earlier. But the law today is PIC. Prior informed consent. The person must be put in knowledge of the possible injuries, and thereafter the consent has to be got. Consent can be either express or implied, but mere knowledge does not imply consent. Okay. Medical negligence cases, 100% you are talking about a prior informed consent. Second defense is, I'll tell you this. I don't know how many of you know it. In Bangalore, cricket match, Bangalore, Royal Challengers Bangalore, and I think it was a blue color. It was actually the Delhi Daredevils, I think. Chris Gayle hit a 6. The kid has come to the match, and the 6 landed on the face of the Chris Gayle. The kid got his teeth broken and had to be taken to the hospital. And he would have had a good case actually. But if he had sued, the court would have probably said, hey, when you came to the match, you definitely wanted Chris Gayle to crack those kind of sixes. Okay. So you wanted that. You came only to watch that. When it was coming to you, you should have caught the ball. If you are a cricketer worth your salt. If not, don't come and watch the match. Right? No, but all these questions didn't come. The Gayle visited the kid in the hospital by about 11 o'clock. The kid was very, very excited actually. And took an autograph from him, took pictures from him and said, I'm not suing you. Huh? So, it could be an implicit consent. Right, here another second defense is plaintiff as a wrongdoer. Again, the law is changing in a very, very big way. It means extirpi causa non oritur actio. Here, even an immoral act on the part of the plaintiff will not give rise to a cause of action. I'm not talking about an illegal act. The classic illustration under the British law we used to give is, if a person goes to a sex worker and contracts a sexually transmitted disease, he cannot sue the sex worker for damages. True. But now most of the brothel houses have been regulated by law, and since the brothel owner, okay, actually now there are no more owners, they all act as independent contractors. let me go to that. They are licensed, and okay, therefore they say even in such a situation there can be a liability. Electric fence. This is a normal thing. Say it happened now in Kerala. Somebody had kept a pineapple concealed, in a pineapple concealed bomb, and the pineapple is eaten by, it's actually meant for wild boars. An elephant comes and takes it, and the elephant died. Okay, here the liability becomes even penal. Inevitable accident. Inevitable accident is an unexpected injury. Bhopal tragedy is not an unexpected injury. It is an expected injury. Okay. The same cannot be avoided and foreseen. Despite reasonable care, the same is an inevitable accident. To succeed in this defense, the defendant must prove he never intended to injure the defendant. For example, I have a coconut tree in my compound. The outer crown of the coconut tree juts into the street. My neighbor regularly parks his car there. He has no business to park it, right? Now, unexpectedly, there has been heavy wind. So, one or two branches of the coconut and one or two coconuts maybe falls on my neighbor's car. Can my neighbor recover money from me? The normal question is yes. Normally, yes. But my neighbor will have an insurance cover and therefore he may not be able to claim from me much. But this is a case where, I have a coconut tree, all right, but I never wanted to injure your car. Now, I exercise reasonable care. Every 3 months, I call a coconut climber. Okay, I pay him a fancy money. Nowadays, they are paid well, actually. In fact, there is a big demand for coconut climbers in Kerala and they get fancy wages, even here in town. The injury cannot be avoided even after taking reasonable care. Okay, that is why now many of the multi-storied apartments are putting up not only dove guards but also suicide guards. In the first floor or the second floor, if you jump from the last floor, mostly you have a safety net breaking the fall of that guy. Because you have to expect that thing. There are bloody idiots who will like to commit suicide from a place to put the house owners in difficulty. In fact, it happened recently in Bangalore. I don't know how it became a case. One neighbor had the key of the flat of the other neighbor. Okay. The person who had the key abused the trust and took away some valuables from the house of the person who had entrusted them the key, hoping neighbors, why are they going to do all those things? Now, once the wife had given the key, saying that if my son or daughter comes, give the key. Now, when the wife went, okay, her husband came on the way. He said, let's go back to the house and then we will go together. When they came into the house, they found the neighbor stealing articles in the house. Okay. Before they could react, the neighbor thought when the door was getting opened, her flat was the next flat, through the window or balcony. She will get into her flat and disappear herself. As luck would have it, when she was trying to transfer from one balcony to the other, she fell down and died. The husband wanted to sue the builder because the builder ought to have anticipated that there will be suicidal people who will be jumping off from the 5th floor or 6th floor and dying. Such accidents occur. Act of God or vis major. Inevitable accident is something different from act of God. Inevitable accident is one that even if you take care, some people will do the same. Okay? Now, whereas act of God is an inevitable accident taking place once in 50 years, 60 years, 70 years. For example, floods in China today. The last flood of this magnitude has taken place in 1974. So now it's about almost 44 years. So this is an act of God. Tsunami. Nobody knew what a tsunami was. After it came, we all know it's common. Actually, it comes in once in 40 years, 50 years in a country like India. Maybe Japan, even there it is once in 5 or 6 years. Volcanic eruption, it occurs once in 30, 40 years. Okay. The criteria is natural. You must know the distinction between inevitable accident and act of God. Inevitable accident is one that happens regularly. Act of God is something that happens once in 50 years. Then the right of private defense. You know this encounter deaths, right? Law permits a reasonable force. What is this reasonable force? This is a very good question. For example, you electrify your feet. Under law of crime, if I am going to commit a theft, I may probably go to jail for 2 to 3 years. But what the owner of the property is doing, he is trying to give me a death sentence immediately. This is wrong. So therefore, if you have to have electrified fences, the electrified fences can only give a non-lethal shock. You understand what I am saying? The private defense must be proportionate to the type of injury that you anticipate. For example, somebody comes and says, show me a knife and say, Dad, you a knife or your wallet? Then what do? I step back and pull out my gun. And that guy thinks, oh God, my weapon is inferior. He starts running. Then I shoot him. Shoot him under a leg. Here, this is not because the threat to my injury has disappeared. Okay? But in law of Texas, they say, in Texas they have about 3 or 4 acre houses actually. Somebody will have to come in 100 yards for you to really get into your house after they get into the compound. Okay? If somebody is seen with a gun or housebreaking equipment, and if that somebody is seen in my property, I have a right to shoot him down. You understand? The force is available not only for the real harm that you will be suffering, but an anticipated harm as well. I don't know what that guy will do. He may not kill me. He may kill me. He may rape and kill me. He may take hostages. A whole lot of situation I will not do. But the most important thing is the force should not be excess and absolutely necessary for the purpose of repelling the wrongful invasion. Okay. Right. A field gun. Okay. In fact, very often, tigers in India or get themselves trapped in food traps actually. Okay. In fact, the department has said it is bad. All right. Statutory authority. Please remember, olden days this happened actually. Okay. That was the time of the railway lines. Okay. The rails those days ran on either charcoal or coal. These engines will emit a smoke. That smoke will have unburnt carbon particles. And the carbon particles may be burning. So sometimes the train goes and in the neighboring land, when the land is fit for harvest, when all the crop is really dry, the falling ash will ignite the land. Okay. But the court held that there is nothing that the plaintiff could do to prevent the emission. So what they had to do? They had to give up the steam engines itself. So, in order to avail the defense of statutory authority, the plaintiff has to prove they were not negligent. The plaintiff have to prove they have exercised due care and diligence. If they are not negligent, if they had exercised due care and diligence, even though the other person suffers a legal injury, the legal injury is there, okay? But a defense is available of statutory authority. Now, this is another case. See, look at this. Servants of the, see, first case, they were different from the first case. The servants of the railway company negligently left trimmings of the grass. Okay. Sparks from an engine got the material on fire. By wind, the fire was carried to the plaintiff's carriage, which was about 200 yards away from the railway line. The cottage was burnt, and the plaintiff was held responsible as the servants of the railway company were not diligent enough to remove the trimmings which were allowed to get dry. So here is a case of negligence. Now we will come to the type of torts. I don't know how many of you. What are you, Anupama? You are an independent contractor with the firm or see, nowadays the trend in employment is outsourcing. See, for example, under the law of vicarious liability, a person will be responsible even when the tortious act is committed by his servant in the course of employment. That means a servant commits an act in the course of employment, the master becomes liable. So what do they do nowadays? He is not my servant. For example, I call my driver into a transport contractor. Right? I tell him, every day you have to come at 8 o'clock, go back at 4 o'clock, and you have to drive me around. You have to have a valid driving license. You are not my servant. I am not your master. You are simply a person who should provide me the service of driving my car. That is again, by whatever name you call it, this is an issue. That is why different legislations have a different definition of a servant. Okay, a contract laborer. A contract laborer doesn't become the laborer of the person in whose place the laborer is working. He becomes the laborer of an independent contractor who hires a contract laborer to work in a factory. Okay. There are three kinds of vicarious liability. First is principal and agent. Second is tortious liability of a partner in a partnership firm for the tortious acts committed by the other partner in the course of the partnership business. Okay. Third is liability of a master for the tortious acts of the servant committed in the course of employment. All right. The basic reason is two maxims here. Qui facit alium facit per se, which means the person who does act through others does it himself. That is justification number one. Yes. Anyone? Justification number two is, the other Latin maxim is respondent superior. Respondent superior means make a person the purchasing capacity That is very, very important. The purchasing capacity, your ability to pay. Hey, you got money, you pay. Do you know the very simple thing? In highway, there will be an accident. Accident between a car and the scooter. Quite possibly, 9 out of 10 times, it is the scooter owner who is at fault. But the policeman will always file a case against the car driver for the simple reason the car driver will have better insurance. You understand what I am saying? Respondent superior. Okay. I always say that sometimes when a two-wheeler guy knocks your car and causes a dent, the dent removal for Innova can be about 50,000-60,000 rupees. And that will be the value of his car, bike actually. Okay, if it is a second-hand bike. So, please remember, even for availing this vicarious liability, if there is negligence, for example, in the absence of a driver, the conductor drove a bus. Okay, the bus caused an accident. In this case, the court held the driver was negligent in allowing the conductor to drive. Okay, therefore, the employer was still held responsible. And nowadays, all transport corporation, unless you have a driving license also, you are not appointed as a conductor. Okay, so therefore, that question will not be applicable here. All right. Now, two important things. First important thing is, number one, you are responsible only for the acts of your servants. You are not responsible for the acts of an independent contractor. Okay, who is an independent contractor? For example, I don't know how many of you know it. When Infosys was building its that funny-looking exotic compound, which is just next to that Electronic City Highway, the contract was given to Prestige Builders. Mr. Irfan is one of the most highly regarded, Prestige Builders. You must be knowing this buildings developed by them. And there was a ramp broke and about 40-50 people died. Mr. Irfan was prosecuted and his company, out of his insurance, paid all the people, and Infosys was held not responsible because Infosys had exercised due care and diligence. They had appointed an independent contractor. That independent contractor was the best in industry. So therefore, the employer had not been negligent. Okay, the main person, Infosys, was not negligent in causing the death of the migrant laborer. And finally, Mr. Irfan is still facing a criminal prosecution, 304 Part 2 in Bangalore courts actually. Then the next question that comes is, tortious act committed by the government servant. In this connection, I refer you to my Satangulam blog. I not written very much on law of tort. That's actually more a criminal law blog. Sometimes the government servants do something illegal. Let us take the Satangulam tragedy. There has been a violation of quarantine laws. The victims, Benny and his father, had definitely violated the directions under the National Disaster Management Authority Act. They can be prosecuted, but when they are prosecuted, should they or should not be released on bail? 2, can they simply call them to the police station and detain them? So there are a lot of illegalities there. Illegalities that is apparent on the face of the record. Now, in such cases, the government itself grants compensation, which is called as ex gratia compensation. You know why? There was an earlier case. In that earlier case, Kasturilal versus Union of India here, 1956. In fact, this girl, Gayatri, told me that, sir, they are citing a case. If it is a case like Kasturilal versus Union of India, if it is a case like Menaka Gandhi versus Union of India, if it is a case like Keshavananda Bharati versus Union of India, Sangari Prasad, Sajjan Singh, these cases you can prepare. But please remember, nowadays the teachers have been directed to avoid giving a case number and giving three precedents, answers and say, such and such case is the authority to this proposition, 3, 1, 2, 3, 4. That type of questions aren't correct, and I expect less of that actually. Look at this illustration. Remoteness of damages. Okay. In jure, non remota, sed proxima spectator. That is the Latin maxim. I think I read it when I was a law student. And as I told you, I had not been studying law, teaching law, taught all this time. It only means in law, a person is responsible for the direct consequences of his act. He is not responsible for the indirect consequences of his act. How do you distinguish the direct consequences from the indirect consequences? Under law of tort, you have a concept called chain of causation. If the chain of causation is broken, okay, then the damage will become an indirect consequence. That will become a remote damage, for which the dependent need not be held responsible. Remoteness of damages is a defense. Remember that. Okay? I can only anticipate, for example, I am driving my cycle negligently. I knocked down a pedestrian. That pedestrian was a terrorist. He has been carrying a bomb. The bomb goes away. In that accident, the pedestrian and 4 other persons walking on the road are severely injured. Very close to the accident site, there is a petrol bunk. The petrol bunk catches fire. The person who actually responsible for the accident, the person who carried the bomb in his pocket, is responsible. Okay? By knocking down a pedestrian is unlikely to kill 4 people and cause the burning of a petrol bunk. In this case, the chain of causation has been broken. The negligent rider in this case cannot remotely foresee all these damages. So therefore, it is a good defense. Okay, let us talk about this. Shia cart versus Sharad. A threw a lighted cracker. It fell on B. In order to save himself from the lighted cracker, B threw it again. It fell on C. C threw it. Ultimately, it fell on D and it burst. D was injured. In this case, D can only recover compensation from A, not from B, C, and D. Because here the chain of causation is not broken. C and B did what every reasonable man is expected to do. Even if A had been in the position of B or C, he would have done that. So in this case, the remoteness of damages will not apply. Okay, a very important case. I'll stop this with this case. Okay. It is a well-known case in law of tort. Defendant chartered a ship. The ship was used for transporting benzene and petrol in tins. Okay, so the ship owner is expected to know that they were carrying an unusually sensitive cargo which is likely to catch fire. Due to leakage of these tins, actually this fault is due to the fault of the person who is transporting the goods actually. Some contents collected on the hold of this ship. Due to the negligence of a dependent, an iron plank fell. That caused the spark, and the spark ignited the vapors. Three things here. Number one, the person who had put in the oil cans must have ensured that everything had been sealed properly. It is not humanly possible for the ship owner to inspect each one of the can and see whether they are closed or over. All right. There, the ship owner is not responsible. But the oil leaked, When it leaked, it accumulated in the ship. Can you carry a highly flammable material over a distance of about 10 or 20,000 kilometers? You shouldn't. Iron plank fell. Was there negligence on that? Yes. If the spark is the direct result of the iron plank falling, then there is negligence. It was held that the owners can recover the entire loss of 2 lakh pounds, even though rare. How many times when an iron plank falls, there is a spark? Many times there isn't. The loss in question can be considered as the direct consequence of the wrongful act. Okay. And I think what is the time now?
So we started at 6:30.
Huh?
We started the.
Okay, we started 10 minutes late.
No.
But many of them have 3 minutes late.
Half an hour.
Half an hour. That's bad.
Yes, sir. 6:34 we start.
6:34.
Was when we opened this PPT.
Okay. Yeah, today. Okay, we should. Okay. Now we'll continue. We'll finish it in another. This case actually, wagon mount case. There's wagon mount 1 and wagon mount 2 also. So all these are. If there is going to be a case on this, there will be definitely one. A ship carrying oil was chartered, taking fuel oil to the Sydney port. Distance of about 600 feet, the respondent carried out repair works that used extensive welding. Weldings, they use the burning torch, and that torch uses super fuel like acetylene and oxygen. So, its ability to cause damage is phenomenal. Due to the negligence, see how all it happens here. Due to the negligence of the ship servant, a large quantity of oil was on the water. The water was floating. The tidal currents carried it to the wharf. The wharf is 600 feet away. Okay. The spilt oil was floating. 60 hours after the spill, a piece of molten metal. It is not any fire here. Okay. Welding, they use metal, and that metal fell from wharf on the floating cotton waste. Okay. If there had not been a cotton waste, the floating oil would not have caught fire. The cotton waste accumulated the split oil and it caught fire. Privy Council held that damages can neither be considered as direct nor foreseeable from the original act of the defendant. All right. Next is trespass to person. There are 4 types of trespasses: assault, battery, intimidation, and false imprisonment. They call it as mayhem. Okay. Mayhem also is okay. Please remember, when I want to slap you, I take my hand with a lot of force and exactly stop before your cheek begins. Many people do that actually. Actually no hitting, but you are putting that person to a fear of a possible injury. Suppose when I do that, I hit, then it becomes battery. Then as every battery has in it an assault, but not assault, all assaults result in battery. This is a subtle distinction you must understand. Intentional infliction of physical harm without lawful justification. Mother beats the kid. Father beats the kid. Primary school teacher beats the kid. Now, all this today will come under child abuse. Mother and father probably will get away. But there is no way a school teacher can get away because intentional infliction of physical harm or pain without lawful justification. Earlier, the teachers had that what you call as a quasi-parental authority. Now, they still have that authority. That doesn't give them a right to beat actually. False imprisonment. Okay. This is unreasonable restraint, which is total, and that has the what do you call? I'll give you one interesting illustration. Two cases I'll give. One is the Stanley versus Powell. A group of people went for a peasant shooting. One member of the party fired at a bird sitting on a tree, but one of the pellets hit the branch, and the pellet was reflected by solid wood and fell on the plaintiff. Okay. This was neither unlawful. Oh, neither lawful yet. In the show. This act was neither unlawful nor negligent. So this cannot be considered as a, what do you call, an assault or battery. In the false imprisonment, I think it is Bolton versus Jones. I don't know. I mean, probably Malavika, you can correct me. Actually, what happened is there was a boat race, and the vantage point for watching the boat race is a bridge which was there across the river. And the person who organized the race had taken proper permission from the municipality. And that person was collecting an entry fee actually from everyone who was in the bridge at that point of time. The plaintiff wanted to cross the bridge. He told the organizers, look here, I am not interested in watching your boat race. I just want to cross the bridge and I will go away. Only when I stand there and watch the race, I have to pay. The organizers refused that. But they didn't put him in jail or anything like that. They retained him till the race was over. After the race was over, he was allowed to cross the bridge. But he said, for more than 3 hours, I had been unlawfully restrained. But the court held in this case that the restraint is not total. For it to constitute false imprisonment, for it to constitute false imprisonment, the restraint must be total restraint, on the liberty of individual. Since he was allowed to go in the opposite direction, he was quite free. They said that this is not that. I think, Bird versus Jones here. Body. I call it Bolton versus Jones. Sorry, it is Bird versus Jones. I think I've done that. Right. Okay. We will take up the other thoughts and one more incidental lecture tomorrow. I have been in front of the computer since 2:30 in the afternoon today. 3 o'clock actually. All right, we will continue our classes tomorrow, and as we agree, Malavika will begin tomorrow's class, hopefully at 6, and I am planning to administer you people as some kind of a mock test also. Let's see how that goes actually, right? I think you can close, and any comments? What is the time now?
40.
9:40, it's good enough.
7:40,
Everybody will
7:40.
feel busy also here. Most of them will have work in their houses also. Yes, we want to change. I'm seeing the screen. Any of you have any comments? Okay. Right. Malavika, you are going to begin tomorrow's class. An analysis of today's class with respect to the questions that you found in the torsions covered today. You can also say